So again, thank you everybody for joining us today. I'll turn it over to Christina, my co-presenter, to introduce herself.
Hi, everyone. Thanks, as Kelly said, thanks for joining us today. I'm Christina Velez. I'm the Legal and Policy Director here at ASISTA, helping out Kelly, my esteemed colleague Kelly, with this webinar.
Thanks, Christina. We'll go to the next slide, please. So then we had the OVW disclaimer, just let folks know that this webinar is funded by the Office on Violence Against Women. We thank them for their support of our TA work. Without them, this webinar would not be possible. Just a reminder for folks that what we're talking about today reflects our views and may not necessarily reflect the views of the Department of Justice. For our learning objectives, the hope is that by participating in this webinar, you will be better able to, number one, describe USCIS Policy Manual changes regarding VAWA Self-Petitions and 8 U.S.C. 1367, to determine how USCIS may adjudicate certain case types after implementation of the new changes, and to adapt your practices to the new requirements. Next slide, please. So for our agenda, we'll have two main sections. The first section will be the changes to USCIS Policy Manual sections on VAWA self-petitions. Then we'll stop for some Q&A. Then we'll move to Christina's section, which is changes to USCIS's interpretation of 8 U.S.C. 1367. And then throughout, we'll be talking about how to enhance USCIS adjudicators' perception of survivors' credibility. And then we'll take more questions at the end of the webinar, and then we'll finish with takeaways. Next slide, please. So starting with VAWA self-petitions, again, just a reminder to folks that these changes were effective December 22nd of 2025, and they applied to petitions that were pending on that date, as well as any self-petitions filed after that. So they were retroactive to already pending self-petitions. Next slide. So the first thing I'll talk about are evidentiary matters, because a lot of the policy changes were related to interpretation of what the any credible evidence standard means. So many of you are probably familiar with the any credible evidence standard. USCIS has conceded that the standard is statutory, but they have really honed in on the part of the statute that says USCIS has the discretion to determine the weight to be given any evidence and to determine whether evidence is credible. So they're conceding it's statutory, but really honing in on their discretion. And they have this pretty rigid definition of what is considered credible evidence. So they have noted that credible evidence is both externally and internally consistent. They say that it has to be plausible and it also has to be sufficiently detailed. Here at ASISTA, we've always encouraged practitioners to submit detailed and specific affidavits from survivors, but this is going to be even more important now with this new language from USCIS. When talking about affidavits, again, USCIS is creating these pretty strict standards. They're saying that the affidavit should have a lot of detail about the person writing it, including their address and where they were born. And USCIS has stated that they will give less weight to affidavits that lack that information. USCIS in this update also focuses a lot on corroboration. Obviously, sometimes in VAWA self-petition cases, you won't have corroboration. If that's the case, it will be more difficult to win that case, especially in this climate, but you can push back on that requirement if necessary. You could argue that evidence that is detailed, specific, and internally consistent can still be credible, even under USCIS's really strict definition, even if it's not corroborated. USCIS has also imposed new requirements on photographs, which I know a lot of folks use, particularly to prove good faith marriage. So USCIS is saying now that you have to identify not only when and where the photo was taken, which I think many folks probably already did that, but now they're also saying that you have to identify the photographer. So these are all important things to keep in mind for photographic evidence. USCIS has also mentioned psychological evaluations, which I know some folks use. Again, they're not a requirement, and we don't want to be requiring survivors to submit to evaluations as a condition of representation, but I know a lot of folks use them. Regarding these evaluations, USCIS now wants there to be proof that the evaluator treats the survivor so that there's like an ongoing therapeutic relationship with the evaluator, or that the person doing the evaluation thoroughly and adequately evaluated the survivor. And in keeping with this emphasis on detail, USCIS wants all of this evidence to be detailed. The evaluation should contain sufficient details, and the evaluator should also explain how their professional training and experience led them to any diagnoses. And the evaluator will also need to include their CV or their professional certifications along with the evaluation. So basically, the takeaway here is that you want the person doing the evaluation to either be like the survivor's therapist, for example, someone who has an ongoing relationship with them, or you want to make sure that it's clear that this person really did thoroughly evaluate the survivor and then they explained how they came to any diagnoses. So you want to make sure you're reading these evaluations before you submit them to USCIS. USCIS also, consistent with their emphasis on fraud in other contexts, has said that if there's a survivor who in the past has submitted a fraudulent document or knowingly made a false statement to USCIS in the past, they have said that could undermine the credibility of all of their evidence, even the evidence that is not fraudulent. This isn't actually new in practice. I saw this happen in the Biden administration, but the emphasis in guidance is important to be aware of. It's showing that this administration is really going to be focused on fraud. If you're working with a survivor who has in the past made a false statement, it's going to become even more important that the evidence that you provide is corroborated, because USCIS is going to be, unfortunately, much less likely to believe what is in the survivor's affidavit if it's not corroborated. And of course, in many of these cases, the false statement can be connected to the abuse that the survivor has suffered. And in that case, you'd want to show how is there that connection with evidence. And then you can argue that because there's a connection to abuse, the false statement is not voluntary. And because the false statement wasn't voluntary, they can't ascribe the survivor less credibility because it was not a knowing and volitional, conscious false statement. And then a Hail Mary argument that you could also throw in is that a prior misrepresentation should not alone prevent the approval of a self-petition, because Congress actually the fact that they created a special inadmissibility waiver for VAWA self-petitioners who were adjusting shows that they knew that at least some folks would get an approved self-petition, even though they misrepresented. Otherwise, they wouldn't have created the waiver at all. So you could say that because of that, that shows that Congress intended that misrepresentation alone should not prevent someone from being able to get their self-petition approved. Next slide. A big change is USCIS is now saying it's a requirement to submit evidence of the termination of the abuser's prior marriages. The prior policy manual language said the survivor should submit this evidence, and now it's must. There's obviously a host of problems with this. In many cases, for safety reasons, the survivor won't be able to obtain, for example, the abuser's divorce certificate from their prior marriage. But if that is the case, you could consider alternative ways to prove termination, along with a statement from the survivor about why they can't access the primary evidence of the termination of the abuser's prior marriage, and then also facts that would support an intended spouse argument as a backup. So the intended spouse rule is statutory. So USCIS, they can't remove that as an option through the policy manual. But you would want to make sure that the evidence supports the elements of the intended spouse rule. So to do that, you would need evidence that shows that, one, that the survivor believed that they married the abuser, that was their subjective belief. Two, that there was some sort of a marriage ceremony between the abuser and the survivor. And three, that again, the survivor subjectively believed that the abuser was free to marry them, even though that was incorrect, but that they subjectively believed that. And fourth, that the only reason that the marriage is invalid is because of the abuser's bigamy. So if there's a case where you can't get the abuser's divorce certificate, for example, you want to make sure those facts are present somewhere in the filing to support that intended spouse argument. You'll also see that USCIS is casting doubt on birth certificates that are registered after the birth. We know that this does happen sometimes. These won't be an auto bar to establishing a relationship. These would be most relevant when cases for abused children or abused parents. But if you are trying to establish that relationship using a late registered birth certificate, do try to also get secondary evidence like hospital records or a baptismal certificate or trustworthy affidavits from people who have knowledge of the circumstances of the birth, and then also have the survivor explain why the birth was registered late or why they can't get other types of evidence like baptismal certificates or hospital records. Next slide, please. So then evidence of battery or extreme cruelty. A big change here is that now USCIS is saying that the abuser must have had U.S.C. or LPR status at the time of the abuse. USCIS had not taken a clear position on this before, so this is a pretty big change. Their justification for this position is a BIA decision called Matter of LLP, which held that for VAWA cancellation, so an entirely different form of relief, for VAWA cancellation, the abuser must have been a USC or LPR at the time of the abuse. In the policy manual, USCIS didn't offer any reasoning for why LLP supported their position. They literally just cited it in a footnote, and that's all. I think it's significant that LLP's reasoning is based on a statute that the structure is very different than the VAWA Self-Petition statute. And the difference in the statutory structures, lack of explanation for including this decision, are potentially avenues to challenge this in another forum. But remember, though, that at least at the USCIS level, the survivor will likely be NTA'd after a denial for this reason, even if there is some sort of a dispute pending in another forum. And you want to factor in that possibility when you're developing a case strategy. The policy manual also appears to apply a stricter definition of battery or extreme cruelty. They reference dictionary definitions of both batter and extreme, which is a little interesting because there's regulations that explain what these things mean. I would argue that should control, but they reference these dictionary definitions. The definition for batter, they're focusing on repeated blows. So it's like they're creating this heightened standard for battery. And then especially for extreme cruelty, they're using a definition of extreme that includes this language about something being to the utmost possible degree. So they're creating this heightened standard of what this term extreme cruelty means. The helpful thing is that USCIS has maintained that the focus in terms of whether something is extreme cruelty is whether the abuser is attempting to attain compliance from or control over the self-petitioner. So although they're on the one hand creating this heightened standard, especially for what is extreme cruelty, they're also saying the ultimate question is this abuser trying to obtain control over the self-petitioner? That's the question in terms of whether there's extreme cruelty. All of that said, it's clear that USCIS is moving away from survivor-centered adjudication practices, and we can no longer assume that VAWA adjudicators will have knowledge of domestic violence dynamics. So it's really important to include materials on that, especially if this is a case that does not involve physical violence. And there's a good resource called the Learning Community, and there's a link to it in your materials index that has some good resources on DV dynamics. If the client is working with a domestic violence advocate, it can also be a really good idea to include a detailed letter of support from that advocate that contains specific information about instances of abuse, and most importantly, an explanation of why, based on the advocate's training and experience working with survivors why they think that this counts essentially as domestic violence. And if possible, I think it's going to be important to attach the advocate's resume or some sort of evidence of their certification. I know some states have specialist certifications for advocates. It's going to be important to attach that evidence as well. And then you might also consider research articles or even expert affidavits in some cases, particularly if this is a client who comes from a community where DV might look different. Like, for example, the LGBTQ community or the deaf community, where there's certain behaviors that are considered DV in that particular community, but might not be outside of it. Next slide, please. Joint residence. So perhaps the biggest change from all of this is the change to the joint residence interpretation. And I say that because it's an absolute complete 180 from what USCIS said in 2022. So under the new policy, USCIS is saying that the survivor must have lived with the abuser during the qualifying relationship. So for example, while they were married, or if this is a case of a parent filing based on abuse by an adult son or daughter, they must have lived with the abuser when they were an adult, when they were 21 or older. This also used to be USCIS's policy before 2022, so it's this very confusing back and forth of interpretations. Litigation was filed against USCIS before 2022 when this was the policy, and it might be susceptible to someone challenging it again. It might also be susceptible to arguments that it can't be retroactive because it's such a substantial change from USCIS's previous interpretation. And there's probably a lot of folks who relied on it when they applied for a VAWA self-petition before these changes went into effect. All that said, those are arguments you can make, but they're not going to win at the USCIS level. And if the self-petition is denied, the survivor will be most likely NTA'd. All that said, for some survivors, they still might be eligible for VAWA cancellation because that form of relief actually doesn't have any joint residence requirement, let alone a requirement of joint residence during the qualifying relationship. Next slide, please. So on good moral character, AS has said that conduct resulting in mandatory detention will be a negative factor in the good moral character determination. So not a bar, but a negative factor. And this is pretty striking because when they say this, they don't distinguish between criminal and non-criminal basis. So presumably entering without inspection, if it resulted in mandatory detention, and I know that those of you in the Eighth Circuit have the decision from the Eighth Circuit saying that yes, that is the appropriate interpretation of the statute. So in those cases, if mandatory detention actually resulted, that could be considered negatively in the good moral character analysis, even if the survivor never committed any type of criminal offense. So USCIS has also noted that if someone doesn't disclose their criminal history, even if it's not material to eligibility, so for example, if someone was arrested but never convicted of an offense, and of course the I-360 doesn't ask about criminal history, but USCIS is still saying we don't care if you don't disclose this. This is going to reflect negatively on your good moral character. And also, similar to if someone made a false statement in the past, it also will cast doubt on the credibility of everything, all of their evidence, if they don't disclose their full criminal history. So the practice tip from this would be, if at all possible, make sure you're screening folks adequately for criminal history before you file, and make sure that is being disclosed fully in the I-360 filing, even though, of course, the form does not ask about it. USCIS also, which they've said this before, but there's even more emphasis on it now, emphasizing that they can consider acts that are outside of the 3-year period if USCIS thinks that those acts are relevant to the self-petitioner's present good moral character. And they've also said that the passage of time alone, since a bad act, might not be enough to demonstrate good moral character. And USCIS has said that factors to consider in these cases include rehabilitation and the severity of the past conduct. but they removed favorable language that had required adjudicators to consider the totality of the evidence, including all the good positive factors, when there are bars outside of that 3-year period. So now USCIS has removed that language that required adjudicators to look at everything, essentially. All that said, of course, you could still argue that if the past acts were related to abuse or trauma, or if the survivor has been rehabilitated and there's good evidence of that, you could argue that these acts are not relevant to the survivor's present good moral character and that therefore they should not be considered because even USCIS is saying they will consider it if we think it's relevant to their present good moral character. If you have a good argument that these past acts are not relevant to the survivor's present good moral character, you could argue that they shouldn't be considered in that analysis. Next slide, please. So I'm sure many of you are familiar with the recent policy update that came out from USCIS saying that they could deny a case without first issuing an RFE or NOID. They had actually said this before, specifically for VAWA Self-Petitions in these December 2025 updates. They had said this, so that's actually not new for VAWAs. So just reiterating that they said they could deny without issuing an RFE. That makes it really important to, first of all, to know what is the required initial evidence for VAWA self-petitions. So make sure you're looking at the regulations and at the form instructions for the I-360 and to make sure that you're including all of that evidence when you file. Ideally, it will be important to include multiple pieces of credible evidence for each element at the time of filing rather than filing what some folks would call a skeletal petition and then relying on being able to supplement later on. We recognize, obviously, there are some cases where you would have to supplement, like if you're on a deadline, but in general, when it's possible, really important to file well-supported petitions at the outset to avoid one of these straight denials, especially in light of the NTA policy, and then at least in the Eighth Circuit, the mandatory detention decision. In terms of interviews, it appears that field office employees who are conducting I-485 interviews, so for VAWA-based adjustment, can try to revoke self-petitions, and there's no longer an agency policy that forbids them from asking about the abuse. So previously, there was language in the policy manual that said you can't basically re-adjudicate the I-360 in a 485 interview. That language has been removed. It's no longer in the policy manual. A couple ways you could respond. First, in terms of revocation, regulations, which they supersede what's in the policy manual, regulations generally require a notice of intent to revoke with the opportunity to respond. So if a officer was trying to revoke a self-petition without notice, I would push back against that, and I'm going to put that regulation in the chat. So I would include that citation and bring that with you to every VAWA interview. And then also, in terms of re-adjudicating the self-petition, even though you don't have a policy to point to anymore, you could still argue potentially, although you'd want to think about, will this be prejudicial to my client or not? But if it's not prejudicial to the client to push back, you could say that discussion of specific facts of the abuse is irrelevant to a 485 interview, which is about the adjustment of status, not about the abuse. And you could argue that USCIS already had the opportunity to review the evidence of abuse. And then also, if the survivor is under the care of a therapist or other mental health professional who could attest to the trauma that the survivor would suffer from having to recount the abuse, you could preemptively, before the interview, if you're concerned that they might try to re-adjudicate the 360, you could bring like a signed letter on letterhead from that mental health professional that talks about maybe the PTSD diagnosis, for example, and that says that they're going to suffer re-traumatization if they have to recount the abuse. It's not guaranteed to prevent this from happening, but that is something you could try. Next slide, please. So now we have a hypo. We have Devika. So she entered the United States without inspection, and she is married to an abusive U.S. citizen, Paul, and they share a 4-month-old child, Tyler. Paul told Davica that real mothers nurse and don't work, and that he would have her deported if she tried to get a job. Davica has milk supply issues, but Paul refused to buy formula for Tyler or give Davica money for formula. Desperate to feed Tyler, Davica shoplifted formula while Paul was at work. She was arrested, but the case was recently dismissed on speedy trial grounds. So the questions are, how might the arrest impact Davica's good moral character, and how would you discuss this with Davica? Give folks a couple minutes to think about that, and then feel free to put your answers in the chat. I'm seeing someone said to host and panelists, so I will read it out to everybody. I also did that, post something to just host and panelists, so thank you, Christina, for putting that reg in the chat. So Emily says, sounds like there could be negative consequences for failing to disclose arrest and should emphasize abuser's control over survivor. Yeah, that makes a lot of sense. Is there anybody else? I'll just give one more minute so we don't miss anybody. Seeing Kathleen says if shoplifting in the last 3 years or even prior can be used for negative good moral character determination, no conviction, so not CIMT, would need to disclose and show outcome. So yeah, both Emily and Kathleen brought up great points here. Emily about emphasizing the abuser's control over the survivor. I think that's a really great point. And then in terms of in the past 3 years can be used for negative determination. Categorical bar to good moral character because there's no conviction and it's not super clear here, but we'll assume no valid admission because it's very hard to make a valid admission, but USCIS will probably say it can come in under the catch-all part of the good moral character statute. Definitely would need to disclose. I agree with that. If she doesn't disclose, even though it's not material per se, would have negative consequences. One thing I wanted to point folks to is that in a situation like this, USCIS might say mandatory detention, and that means no good moral character. The reason they might say that is that theft, even if there's no conviction, can be a Lake and Riley offense. And this is a relatively recent shoplifting conviction, or sorry, not conviction, arrest. So it would fall under Lake and Riley, which was passed in early 2025. And USCIS might say that because someone could be subject to mandatory detention under the Lake and Riley Act for a mere arrest for theft, that means that that will be a negative factor in the good moral character determination. One way you could push back against that is to note that the language in the policy manual is that it resulted in mandatory detention. As far as we know from this hypothetical, it doesn't seem like Davica was actually detained, that she was ever actually in ICE custody because of this arrest. Could make that super technical argument, but just keep in mind that in a case like this, at least possible that USCIS might say, because of the Lake and Riley issue, that in and of itself is a good moral character problem. But then also just getting to what Kathleen said, the mere fact that she's been arrested, they're going to use that against her. I think one of the most powerful things you can do here is to point out the fact that this was pretty clearly related to the abuse. You want to get into a little bit more more details of the power and control between Paul and Davica, potentially could see if there's any indication that Davica's milk supply issues caused any type of postpartum depression or other type of postpartum mental health issue, and if the fact that Paul was making these comments to her kind of exacerbated that, and if he, say, knew about that postpartum depression and knew that making comments like this could exacerbate that, that could support the extreme cruelty argument. And then you can argue that because this is related to the abuse, it should be considered more leniently in the good moral character analysis. You could say that throughout the INA, there's a lot of examples of Congress treating bad acts that are related to abuse more leniently than other types of bad acts. There's a few places where they do this. There's actually a waiver to conditional bars to good moral character for VAWA self-petitions if they're related to the abuse. So here, oddly enough, that wouldn't work because there actually is no conditional bar to good moral character. But let's say there was, there's that waiver. There's a waiver for VAWA cancellation, good moral character bars, if they're related to the abuse. And then there's also, so for folks, for example, who've been admitted to the United States on a visa and then get put in removal proceedings, they're subject to what's called grounds of deportability. There's a deportability ground for a domestic violence offense, but there is a waiver of that ground if someone can show that the domestic violence offense was related to actually themselves being abused. So you could argue that the fact that there's so many examples in the INA of bad acts being treated more leniently because of a connection to abuse, that similarly here, Davica's mere arrest, which didn't even result in a conviction, should also be treated more leniently because it was related to abuse. You could also bring in arguments that this wasn't really a voluntary act of hers, and because it was related to abuse, it can't, and it wasn't voluntary, it can't be said to reflect on her good moral character. Because good moral character should be a question of whether a person's voluntary actions are within the bounds of what's acceptable in that community. But if the person's actions are not voluntary because they're the result of coercion and abuse, they shouldn't reflect negatively on their good moral character. All that said, though, like I'm sure you all have seen this, in this administration, discretion is really tightening, and emphasizing positive equities is going to be even more important now than before. So, of course, you would want to include the evidence of connection to abuse and the arguments, but that probably won't be enough. You also want to introduce positive equities outside of the connection to abuse to establish that Davica is a person of good moral character. So, for example, her U.S. citizen child's birth certificate, evidence of if the child has any medical needs that Davica needs to be here for to help him with, if she's getting any type of victim services here in the United States. So making sure you're including those factors in addition to the connection to abuse. Next slide, please. Again, I won't spend a whole lot of time on this just because unfortunately, like USCIS has already said that these changes are retroactive, and USCIS is probably going to stand by that, and I would think that the Administrative Appeals Office would. But if you're dealing with this type of situation, particularly if you already filed, I guess the reason that this would come up is if you already filed a self-petition, say 3 years ago, and then it's coming up for adjudication, and it would have been approvable under the old policies, and now USCIS is saying because of these retroactive policies, your client loses, you could make arguments to USCIS about retroactivity. Here on your screen is the test that the BIA uses for whether an agency rule will be applied. And for an example of where they actually applied this favorably, you could look at, there's a decision from earlier this year called Matter Forjo, where they made a change to how they interpret 237 A1H waivers, but decided not to apply it retroactively and did some analysis in terms of why they wouldn't apply it retroactively. So if you wanted to take a look at that, you could, just to think about, again, the arguments that you would be making in that type of situation. I don't think that USCIS would buy them, frankly, and I don't think the AAO would either. But if you wanted to get them in the record for the future. Those are some places you could. Next slide. So in terms of practical tips, can't stress enough how important it is to submit evidence about domestic violence dynamics. Include the power and control wheel with your submissions. Include some evidence from the learning community and some other reputable sources. And also include arguments about those dynamics in your cover letters. Also, corroboration is going to be really important, even if you can corroborate things that seem small. Say the survivor said in her statement that she was at the doctor on a certain day. If you can corroborate that with evidence of the visit summary from that day, that helps enhance the survivor's overall credibility. And that's even more important if your only evidence of one or more of the elements is the survivor's statement. If that's the case, you want to make sure you can do everything you can to make the statement seem as credible as possible. And if you can't get corroboration, the survivor should ideally always explain why in her affidavit. And then you can argue in your cover letter that corroboration, there shouldn't be a bright line requirement for corroboration because the statute doesn't require that, and it would be contrary to the congressional intent behind the any credible evidence standard, which is a recognition that domestic violence survivors might lack extensive documentation to apply for relief independently of their abuser. And you'll also want to argue about why is the survivor credible despite this lack of corroboration. So, for example, is their statement detailed and is it internally consistent? And is it externally consistent with other evidence in the filing or prior immigration filings? Also, make sure you're reviewing filings for consistency. This is something we've always encouraged, but going to be even more important now, since inconsistencies can affect the credibility of other pieces of evidence. And if there is an inconsistency, ideally the survivor should explain it. On the theme of consistency, important to know what was filed previously. If the survivor says something now that is inconsistent with something that's, for example, in their A file, and there is no explanation for that inconsistency, that is going to affect credibility. Briefing the reasons behind the any credible evidence standard also going to be really important since there was language previously in the policy manual about why that standard existed to guide adjudicators, but USCIS removed that language. So important to brief the reasons behind that. And then in terms of supplementing, since you have to show that joint residence was during the qualifying relationship and that at least some battery or extreme cruelty occurred when the abuser was a U.S. citizen or LPR, make sure you have enough evidence to prove those things. Sorry. And if you don't, we encourage you to supplement your filing with that evidence. And then finally, if there's any good moral character concerns, be sure to include evidence of positive equities. Next slide. Sorry, everyone. I'm having a coughing fit. So, someone had asked about, can you elaborate on the Eighth Circuit mandatory detention decision that was mentioned? So that decision is Herrera Avila v. Bondi, which I will get the citation for that in a second here. So basically, the BIA in matter of Yahare Hurtado had said that folks who e-weed are subject to, mandatory detention. And many circuits have disagreed with that, but the Eighth Circuit agreed with Yahare Hurtado. So that's the case I was referring to.
Sorry, Kelly, I didn't know exactly about that case. I would have jumped in. Sorry about that. I'm putting more information about it here. Yeah, that's it. Okay. Also, I know someone put a question in the Q&A box, so just want to draw folks' attention to that. The question is, can USCIS's evidence determinations be reviewed by the board if they are clearly erroneous? Do you agree with my answer there, Kelly? Give me thumbs up.
Yeah, appeal the denial. Yeah, I think that makes sense. I have not ever heard of someone appealing a 360 to the BIA? I don't know much about I-130s, but
I think
some
it's
sort of
because
rule
the
that,
I-130.
yeah,
Yeah.
about that. Um,
I-130 denials can be appealed to the
right.
BIA. Okay. So if no one else has any questions, we can let Kelly recover and I'll move us on to the next section. Thank you, Kelly. That really was great. So let's go to the next slide. Let's see. Policy manual changes, part two, 8 USC 1367. Like the VAWA policy manual changes, these were also made effective as of the day of their release, December 22nd, 2025, and do also apply to all pending and newly filed applications. Let's go to the next slide. So it's good that everyone came to this webinar today because as we've been doing these webinars and as we've been talking to people around the country, we're seeing that some of these policy manual updates are still, people are still familiarizing themselves with them because they were so broad. But before we dig into these policy manual changes, I wanted to note that the section of the law 1367 was enacted in 1996 as part of IRA, and it was updated slightly in 2006 to include references to U&T visas in order to protect the confidentiality of survivor provided information and to protect survivor applicants from interference with their cases by abusers or traffickers. And since then, it's been applied much more broadly than the actual text of the statute. The slide here shows what the statute actually says, but the prior guidance for implementing this section is much broader. It's in a memo that's posted on our website. It was posted in 1997. I'm going to put it in the chat here and represents a lot of the way that people think about 1367 protections, which is to say that they, they were applied quite broadly, right? To protect against the use of information provided by survivors in the course of any kind of enforcement proceeding or to trigger any enforcement proceeding, and also to treat abuser provided and perpetrator provided information as inherently suspect for all purposes. So looking back at the slide here, 1367 encompasses two provisions that apply to all protected persons, meaning those who have filed UT or VAWA related applications. So first is the prohibition against the use of information furnished by an abuser or perpetrator to make an adverse determination of the non-citizen's inadmissibility or deportability, subject to an exception where the protected non-citizen has been convicted of certain crimes, which we'll talk about all of that in a minute. But the second is the prohibition against disclosure of information referring to the protected person to anyone outside of DHS, DOJ, or DOS, Department of State, except in some limited circumstances for a legitimate law enforcement purpose. Here, nothing is really changing with this prohibition, but I wanted to note that DHS is an agency that includes several components, including OPLA, ICE, and HSI. I heard recently of someone who was concerned that HSI had information about their client that had only been included in their U visa petition. Unfortunately, not like isolated occurrence these days. And just wanted to clarify that kind of internal DHS information sharing is not outside of the bounds of what's allowed by the terms of 1367. Previous, I think, discretionary policies were in place to prevent enforcement actions being taken against survivors with pending petitions, but that was a separate sort of enforcement guidance, separate from 1367. Easy to conflate them. Let's see. Also, previously, 13, the USCIS applied 1367 so broadly, as I said, to prohibit reliance on abuser provided information. And if it was going to rely on that information, USCIS would need to obtain independent corroborative information from an unrelated and not prohibited source before making any kind of adverse finding based on that evidence. So the policy manual changes that are most significant here apply to the first provision, and significant in terms of changes are apply to the first provision, that prohibited source provision. So in that policy manual update, USCIS announced its intention to apply the provision as written, which is to say far more narrowly. I suspect this was not done previously, in part because it's incredibly difficult to implement it in that way, as we'll discuss. Well, also, as the memo I shared explains, like I said, such an approach is also inconsistent with the purposes and considerations underlying VAWA, which are arguments that I think can come into play in advocacy, even under this new interpretation. Let's go to the next slide. What is significant about the new guidance is that it no longer reflects that view that information provided by the abuser is inherently suspect, except when dealing with determinations of inadmissibility and deportability, which makes no sense, which, as we know, is not a central determination of eligibility for survivor-based immigration benefits. So what this means is that when it comes to the elements of relief, such as good faith marriage, that don't have anything to do with admissibility, abuser provided information can come in. And this includes information not only provided by abusers in anonymous phone calls to ICE or to USCIS, but also in allegations made in family court records or other kinds of records. So the policy manual says that adjudicators can consider this information without requiring or seeking independent corroborating evidence, as with the policy before. The updated policy manual says that the abuser provided info should be evaluated using established practices for determining the credibility of the information. So these include considering, this is a quote from the policy manual now, includes considering the apparent motivation of the source and the reliability and credibility of the statement in the context of the other evidence in the record. So I would quote that back to USCIS in any advocacy that you need to do to minimize the impact of abuser provided information. In addition, the policy manual states that officers retain discretion to corroborate such statements by third-party sources on a case-by-case basis. So you can still continue to argue that is necessary in order for the information to be considered credible. Filers who receive RFEs or NOIDs or decisions that rely on derogatory information should also cite this policy manual language back to USCIS, right? It could also be important to note the section of the policy manual that deals with specifically with derogatory information. We don't include a slide on this, so I'm going to put some language and some cites in the chat. There is a section of the policy manual requiring USCIS to allow an applicant the opportunity to respond to derogatory information in the record. That's this portion of the policy manual. There's also a regulation that requires, in stronger terms, that the applicant should have an opportunity to rebut any information of which they were not aware. And that is, this regulation is here. And I will also put a quote of what it says in the chat. Sorry, I didn't make it into the slides for some reason. But it is important, I think, to have in your arsenal. So that's what it says. If the decision will be adverse to the applicant or petitioner and is based on derogatory information considered by the service of which the applicant is unaware, they should be advised of this fact and offered an opportunity to rebut that information. and present information. So that's something that we think that folks need to have maybe pinned up in their office to make sure that they quote when needed. Let's see. Oh, yes, the provision as written, 1367 provision, prohibited source provision as written also includes this weird exception allowing DHS to consider abuser provided information even for admissibility purposes if the beneficiary has been convicted of an offense under INA 237A2, even if that offense has nothing whatsoever to do with the information that is being provided by the petitioner or the abuser or the application being filed, even if, or even the applicant's propensity for truthfulness. This section 237A2 also relates to deportability rather than inadmissibility. And so survivors applying for VAWA URT relief are usually affirmatively seeking an immigration status rather than defending against charges of deportability, right? Except in the VAWA cancellation context. So this is a section that doesn't really match up in some ways to the position of the petitioner. So let's look more closely at that in the next slide. Okay, I'm not going to go deeply into this because the more I have thought about this new interpretation, the more I feel like I understand what it's about. But so here are what the offenses are that are included in 237A2. It covers more than criminal convictions. The statutes, if you look at 8, there are like non-criminal grounds and admissions and things like that as well, pertaining to deportability. But for the purpose of this exception to 1367, we're only looking at grounds that require convictions. These include CIMTs, aggravated felonies, controlled substance offenses, with those exceptions that do still apply. Another thing that we've noted is that several of these offenses in 237A2, because they relate to deportability, include language of after admission. So we don't yet know if or how courts will apply this exception, how it will arise in decision making, given the complexity of it and how it would be applied. If it does come up, we do urge folks to cite the text and argue that if their client has not yet been admitted, that subsection should not apply. For those who were admitted and on valid visas and overstayed, I would also just cite the within 5 years limitation where applicable for CIMTs. There is some precedent for applying deportability provisions to limitations on eligibility, and that's in the context of cancellation of removal. But again, I will say I don't think that USCIS has given very much thought to how it will apply this prohibition as written and the exception here as written, because I think the point of this new textual application of 1367 overall is to allow in abuser or perpetrator provided evidence without that inherently suspect thumb on the scale. And I think that's what we're going to start seeing more of potentially as we move forward with to see how these adjudications are made. Let's go to the next slide. Here we have a poll. Ali is married to Soraya, an abusive LPR. He does not have any convictions. Soraya has frequently threatened to call ICE on Ali. Ali has filed a VAWA self-petition and is worried that USCIS might find that his marriage to Soraya is not in good faith if she calls ICE and says that he only married her for a green card. So after everything that I've said, do we think that Ali's fears are well-founded? I don't know if we have a poll to launch or folks can just put their answers in the chat. Yes. Folks are saying yes. Everyone's saying yes. Yes, of course. His fears are well founded. He doesn't know if she will call ICE, but he knows that, or his attorney knows that if she does call ICE, her evidence will go to the elements of the offense of the his eligibility for VAWA, right? Good faith marriage, and that will not also carry this inherently suspect red flag on it that requires additional corroboration. So his fears are well founded, but hopefully you have some weapons in your arsenal to use to push back on just a sort of unthinking reliance on her allegation. Let's go to the next slide. Okay. So these 1367 updates contain additional changes that are also super important for practitioners. So I'm going to review them quickly here, and then we're going to, I think, try to answer any more questions that folks may have. First, USCIS has stated that the registration and change of address requirements do apply to protected persons, and that protected persons are not excused from providing a physical address when required. So this is two things really. And they've said it elsewhere, I believe, recently also that, oh, maybe in the updated registration regulation that U.N.T. and VAWA I-360 petitioners are subject to the registration requirement and the associated change of address requirement. They've also been harping a lot on the need for applicants to provide a physical address. We have seen rejections and denials of applications in which, oh, not rejections, that we've seen, actually, we have started to see rejections and denials of applications where the applicant does not provide a physical address. USCIS in the previous version of, oh, thanks, Kelly, for putting that in the chat. In the previous version of the 1367 Policy Manual language, USCIS stated that protections would end when the person is being when the person naturalizes, and then would come back into play upon the consideration of denaturalization. And I'm flagging that because there's a lot of talk about a renewed effort towards denaturalization now. Currently, it's still true that 1367 protections end when the person naturalizes, but they come back only after consideration, but only once denaturalization proceedings have been initiated. There's this sort of, seems like they want to be able to consider information that would be prohibited by 1367 for to consider whether to initiate denaturalization proceedings. Also, USCIS has implied that attorneys or accredited representatives can call the contact center without the non-citizen. I believe that has been happening with some success, a little inconsistent, but that is the sort of one bright spot in all of this. Yes, we would love to hear how you fared with this. Let's go to the next slide. Let me think. Practice tips. Oh, yes. Okay. I recognize that USCIS will apply the prohibited source provision quite narrowly, as we've discussed. We want to also acknowledge that some criminalized survivors won't receive any prohibited source protection. This is a big policy change that unfortunately could cause a lot of harm, even if they do apply it as written. I want to recommend that you argue that information that is provided by abusers is not credible. Maybe even using some of those established methods that are referenced in the policy manual update. Brief arguments against retroactivity where applicable. Prepare arguments on why certain criminalized survivors should still be protected by the prohibited source provision. Once again, going back to credibility overall and the requirement and regulation, which is stronger than the policy manual language, that they be given an opportunity to respond to derogatory information. So be prepared to request that derogatory information, file FOIA requests to make sure that you have the full record of it, of adjudication or whatever they will share with you. Let's go to the next slide. And more questions. I see a question that came in here about do you advise against using the attorney address as a safe address or care of address? Ah, it's been going a hard question to answer. I think some people have still managed to get receipts for applications that were filed using a care of address. Every application can include a safe address. There is always going to be a field for a safe address. My cynicism about the safe address is related to USCIS not always mailing receipts and other communications and items correctly to the safe address. But also, I'm sure everyone is also concerned about the use of an actual physical address for enforcement purposes. But they have said that's required. I also saw a report, fortunately, today, just today in the Sacramento Bee, about an attorney's office that was ICE tried to raid an office because that attorney had used her address as her client's address. And I'm not sure if she used CO properly there, but thank you, Kelly, for adding that into the chat. It's definitely a cautionary tale to keep in mind. Kelly, do you have anything else to add there?
No, I don't think so. I think you covered it. Yeah, I think more, I haven't completely read this story yet, but yeah, I think what we've been hearing was more an issue of including not having a physical address. I think a safe address, like you should always be able to include an attorney address, I think, is a safe address if that's
Right.
where the survivor feels safest. But yeah, the issue is that they don't always send everything there.
And I maybe misread this, but I agree with you, Kelly. The attorney addresses can always be used as safe addresses. Physical addresses, care of, might be a little bit more complicated.
Yeah, definitely.
Take away there.
Yeah. And the practice that folks used to use of for physical addressing confidential, like that's what's becoming a problem.
Tricky, tricky. So for
Yeah.
physical
Yeah.
address, you would recommend using the actual physical address. There's a little caveat there. I definitely, when someone is residing in a domestic violence shelter or a rape crisis shelter, we do not recommend using that actual physical address there because it is confidential as a matter of law in some cases. I would recommend that people provide a letter from the case manager explaining that the person's residing in that kind of facility and what the rules are there. I know that some states also offer safe address programs. Very often those include a PO box, which is not easy to use. I don't know if USCIS, I don't think accepts PO boxes as a physical address, but if it's very important to the client to do that, to use that, I might also include a letter explaining why and explaining that they are currently fleeing domestic violence and are afraid for their safety if they provide a physical address. So otherwise, I do think that USCIS is requiring those. And Kelly is nodding.
Yeah, it sounds right to me.
Fortunate. I know.
Any last minute questions before we go to takeaways?
Sure, Joel.
Favorite learning community resource to include? That's a good question.
It's a
I will
great
admit that I
question.
haven't found a particular one that I'm like, that's the best. I haven't reviewed them enough for that. I don't know, Christina, have you?
I think for me, it would depend on what I might, oops, sorry, I didn't reprint, I'm sorry. I meant to reprint Emily's question, favorite learning community resource, but instead I copied that regulation again. I think it depends on what I would need support for, right? Whether it be maybe some issues with memory, maybe if it is, again, trying to illustrate the dynamics that were in the home, if it's certainly if it's a case that's based on domestic violence, the dynamics that may have been in the home and how they contributed to the client's experience of cruelty and to bolster the argument that they experienced extreme cruelty. So I think there's some stuff like that in there. And given that it comes from real experts on domestic violence and that aren't being created in anticipation of some kind of immigration filing, I think that they should be considered credible.
Yeah, I think that's a really good answer.
Thanks, Kelly.
We'll go to the next slide, please. So for takeaways, USCIS's guidance on the any credible evidence standard makes it critical to include arguments and evidence on domestic violence dynamics and to review filings for credibility and consistency. Fewer immigrant survivors will be protected by the prohibited source provision, prepare credibility arguments, prepare to address any improper primary aggressor determinations, and include copious evidence of positive equities when there is a chance of a good moral character problem. Next slide, please. And then again, most of you are probably familiar with this, but this is just a description of how to request our TA. So we provide OVW funded TTA to organizations that receive LAV, STOP, or LC funding, and those are free one-on-one video appointments to talk about your immigrant survivor case questions, as long as there's some sort of a connection to domestic violence, dating violence, sexual assault, or stalking. So, for example, a question about a VAWA Self-Petition obviously would involve domestic violence. And then you would schedule an appointment by logging into your account on the ASISTA portal and then following the steps here. And then we also have occasional group technical assistance roundtable calls where folks talk about what they're seeing in their cases and strategize together, and we provide some updates. So if you are ever interested in that, hope to see you in one of those. Next slide. So thank you all very much, and thank you, Heather, for your support. And there is going to be a survey that will pop up at the end. And we do ask that you fill it out. If possible, we do read all of your responses, and they help us plan our future trainings. Thank you, everybody, for your participation, and hope you have a good rest of your day.
Thank you.